Welcome to the PinkpillRx podcast, hosted by Katie and Jay Fillmore, where we navigate complex and thought-provoking topics surrounding women with a focus on education. For shorter form content, follow us on TikTok, Instagram, or YouTube at Caters88 or PinkpillRx.
That's KATORS88.
If you enjoy this podcast, please give us a follow and maybe a nice review.
Thank you so much for joining us today. We're going to jump right into part 2 of Family Court with attorney Tashina Gorgone. And just as a reminder, this is not legal advice. Please seek your own legal counsel. We hope you enjoy the episode.
I know, you started out talking about how court is, very sterile environment, obviously. And something that I am divorced. I did go through my own child custody thing. Luckily, it was very, compared to a lot of stories I've heard, very low key, like did not blow up the way that some of this stuff does. So I feel very grateful for that. But something that I was always told was the court doesn't speculate on what could happen. It's what did happen kind of thing. And so with that in mind, is there room for domestic violence education in the courtroom for these judges and for people, I guess, that are making these decisions? Because it is a sterile environment, and does that training help? Is that even helpful?
I'm going to start by saying, yes, I think that there is a call from the bar at large and mental health professionals at large to say we want more of this training. I'm actually participating in a study right now with, it actually might be a university out of Illinois that is researching the roles of family law practitioners in understanding and helping educate about domestic violence. So this was well timed. And one of the things that it asks is, what do you want to see more of? What would help you put on your cases for your victims of domestic violence, your clients who are those victims? Education is a huge part of it, but education has to take a couple of forms. One, education directly to the bench, and by the bench, I mean judges, about not just that domestic violence exists, right? But the elements of coercive control, how isolation comes to play. But almost more importantly, because there is still, rightly or wrongly, this prevailing belief that if somebody was abusive to one person doesn't necessarily mean that they would be abusive to other people, or just because your child saw a person be abusive doesn't mean that that doesn't impact them. There's a lack of understanding or knowledge about the role of observing domestic violence on children. And because the rules of evidence are such that I can't just come into court with a study published, by the American Psychology Association that says, yep, this is real. I can't do that yet. There is a limitation on how to effectively communicate that across the board so that it's universally recognized. One day, we might have enough evidence in the form of journals and data and research that's come out of domestic violence cases that it's become so prevalent that we can kind of, how do I want to say this? So I can walk into a courtroom in Northern Virginia right now and say the real estate market is crazy. And I don't necessarily, we know that, right? It's almost like just an established fact. One day I would love for us to be able to walk into a courtroom and just say, Your Honor, he was abusive to my client and the children witnessed it. And as we all know, that matters. That has a trickle down effect. They're going to perform worse in school. They're going to be more isolated. They're going to mirror that behavior, but we don't have that universality of that data yet for it to be kind of this common knowledge assessment. And so in cases where I have to argue that, or I want to argue that, I have to get the professional in who has hopefully done a custody evaluation or a psychological evaluation of the parents of the child to then give their testimony about their specific opinions about this singular case that's in front of the court. And that might get me the outcome I want on Monday. But next Thursday, I have a different case and I have to do it all over again.
So we need more studies, is what it sounds like.
We need more studies, and it's unfortunate because I know studies take time. I worry, I don't want to go too far afield, but I worry about other, we're almost always in a triage situation, is how I'll say it. You know, right now, for example, one of the greatest tools that a woman in a domestic violence situation has, regardless of the impact on custody itself, is the ability to seek a divorce, right? Right now, Virginia, for example, we have no fault divorce. You don't have to allege cruelty. You don't have to allege adultery. We do still allow those things if you allege them, but you can get a no fault divorce. If something like no fault divorce goes away or is undone, women in domestic violence situations, no amount of studies in the world about what's going to impact child is going to help them if they can't get out of the relationship in the first place. Because right now, there's a discussion happening about what is the longevity or the survival rate of the ability to maintain no fault divorce. And that's where so much energy and focus is going to start going. The studies about what we're doing with kids, I mean, that's very important work, and I hope somebody is out there doing it, but we don't get to participate in that as much when our energy is over here trying to make sure that you can still get divorced in the first place.
Yeah.
Right. Yeah. I did not realize until I started looking into it, the no fault divorce and how like impactful that would be on a large scale if that went away. Now, is that, I should know this, and I apologize that I don't. Is that no fault divorce thing, is that a federal level thing, or is that a state by state thing? Are they trying to get it back to the states, or what is going on there?
State by state.
State by state. Okay.
Which, so like right now, it's great because in Virginia, we have no fault divorce. We do have a longer waiting period. There are always discussions and bills being presented to try to, you know, shore that up, better protect it, do those sorts of things. But the reality is even when something is state by state, you get the wrong people making decisions and that can go away. You get somebody who thinks they can impose a federal rule to override what the states are doing, and it leaves us in chaos until it gets resolved, even if ultimately it's resolved to say, no, wait, you didn't actually have that authority in the first place.
Right.
And so it's something that I'm not an alarmist, but it's on my radar. So it's something that I'm thinking about. And when a client comes to me in a domestic violence situation right now, and I say, okay, we can litigate your case and we can do all of this and we can put on all the evidence and maybe you'll get a divorce hearing 2 years from now, or we can settle your case for 75% of what you would have been happy with and 25% not, but get you divorced. It's ultimately their choice, but it impacts my advice.
This might feel like we jumped around a little bit, but I meant to ask this earlier. When you have the domestic abuse allegations, do you see dads often coming back with alienation?
Yes.
Counterclaims?
Absolutely.
Okay. Can you explain what alienation is?
Another great question and one of my special interests. So it depends who you ask, because there's a school of thought that alienation is not a real thing. It is not a syndrome. It is not a DSM-5 recognized thing. And then there are people that very much believe that alienation is a valid title to put on the result of one parent actively trying to interfere with or distance the relationship between the non-favored parent and the child. I'm going to use alienation for purposes of this conversation, since that's what you used, but I try to avoid using alienation in my cases, both when I have the mother and occasionally I do have the parent who is alleged to be alienated, which sometimes is also still the mother. I try not to use the word alienation the same way I try not to use the word abuse. I think it's a conclusion, not a discussion of the symptoms. When I have a husband or a dad on the other side that claims they're being alienated, that's what I dig into, right? Okay, you can say alienation, but tell me what is happening. Your child is your child is spending time with you. Are you being alienated, or is your wife just exercising opinions different than you for the first time in her life? Are you being alienated, or do you not like that your children actually have a preference and are old enough now to demonstrate that preference? Are you being alienated, or do you not like that your children is an autonomous human being that, you can't control right now? And so when I have the alienator on the other side, sorry, let me try that again. When I have the person who is claiming they are being alienated on the other side, I'm really doing two things. I'm digging down on why that claim doesn't actually have factual support, and I am advising my client to do a little bit more than maybe I would have advised them to do if that wasn't an allegation on the table, right? Give him the tools to dig his hole. He's saying that the children won't transition to him at, you're trying to drop the kids off at his house and they won't get out of your car. Look, I know you don't like it, but let him come pick the kids up at school. Now you've removed yourself from the equation and the argument about whether or not you're the one not doing enough to support the relationship. If you are concerned that he is harming the children and you're trying to take steps, there's a way that I'm going to talk to you about how to go about trying to suss out the legitimacy of that claim. But it's not going to be just immediately withhold the children and tell him you can't. And again, it's not because I think that's like the greatest answer, but it's how to use the tools that we have to get ahead of a claim almost before it can even take it on a life of its own. And so I definitely see that. I think that's almost two sides of the same coin, is where you're going to hear about domestic violence. You're going to hear on the other side that there is alienation, because the person who is claimed that they're being alienated often doesn't have the self-awareness, maybe it's the nice way I can put it, to acknowledge that they might have a role in creating the environment in which they now find themselves. Which again, I'm not saying absolves the other parent of all responsibility, but I definitely think that in court, we then find an unfair amount of the burden being put on the favored parent or the parent that's already experienced abuse to have to try to facilitate a relationship that it wasn't really their fault they hurt in the first place. But you almost have to go that extra mile to negate the claim, so that all that's left is, Your Honor, even if you strip it all away, at the end of the day, this person doesn't have the relationship with their children that justifies the amount of custody they're asking for, and they failed to take additional steps on their own that would have improved it.
I know earlier we discussed orders of protection and how getting one after you've initiated a divorce can be looked down upon by a judge, and you're trying to get a leg up, I think is how you phrased it. So does a judge look at that similarly if one parent is claiming alienation in the divorce process, and then the other parent decides to, oh, well, we're just going to have you pick them up at school, we're going to do this and that? Does the judge also view that as, well, now you're under a microscope, you're just trying to stop what you were doing and make it look better? Or is it different from the order of protection type situation?
No, I think that's a good question. I think that judges are skeptical of the phrase alienation in almost the same way that they are going to give a little more scrutiny to allegations of domestic violence. I'm not trying to diminish either of them. I know I keep repeating that, but it's just part of my conditioning, I think. But you have to think about, to an earlier point that we were talking about, the number of cases that might come through our office or come through any family law office is this many. The number that settle are this many. The number that maybe settle after part of a trial is this many. And so like, this is the percentage of cases that are actually getting to a court, to a judge. And if you think about that, they have a lot of similar themes. They have the cases that aren't settling or going to full litigation, or the cases with domestic violence or coercive control or alienation claims. And so from the judge's side of the bench, they're seeing a lot of the same things every day. And I think that does make them look at it on all sides with a closer eye, because maybe last week they did see the horrible domestic violence case. And now, rightly or wrongly, that's kind of the standard they've set for themselves of, how does this one compare? They might have seen a legitimate alienation case, which you might also sometimes see referred to as like resist and refuse, where a child resists or refuses going with the other parent. They might have seen a legitimate resist and refuse case where one parent, whether it's because of their own anxiety, their own issues, just has really actually poisoned that relationship between the child and the disfavored parent. And that takes a lot to show that. But if that's something a judge has successfully seen, then how does this case, when you, sir, come in claiming alienation, stack up to it? And I do think that that's important, because I'm not here to malign our bench. Our bench works very, very hard to weigh each case on its individual merits, but we're all human. And we all are also secondary trauma victims, hearing this every single day and dealing with it every single day. And so I don't think they can help but sometimes compare what to client A might be their worst day, but look at client Z that was in front of their, courtroom last week, who had an exponentially worse time of it.
Do you feel like, as a female attorney, that you have faced any unique challenges, or like felt maybe more dismissed or unfairly treated by judges or other lawyers or anything like that? Like, does your gender play into bias at all, do you feel?
Yes.
Okay. Can you elaborate, or if you feel comfortable?
There are a couple of ways that this can come into play. And I'm going to caveat this by saying that thankfully, some of this is just things I've observed and not things I've personally experienced, but some of it is personal experience as well. There are some judges in certain jurisdictions where I practice, who are male, who are going to talk over me more than they're going to talk over my male counterparts, who are going to make comments behind closed doors off the bench about whether or not they could see down a woman's blouse when she was at counsel table. There are going to be deputies, well-meaning deputies, that are going to confuse us with court reporters, or the client. I can say I personally have experienced less of that. For better or worse, I think I come in with a very masculine energy when I come into court. And so people don't mistake me for the court reporter. But I have a very, very well-respected colleague who just last week, it became a whole topic of conversation on one of our trial listservs, that she, despite having been in practice for 20 years, was mistaken for the court reporter. I have male judges that won't be as deferential of my female colleagues' personal time. So for example, a male attorney might say, "Judge, I can't stay late tonight because I've got to go coach my son's basketball team tonight." And the judge is like, "Oh, that's so wonderful. Like, of course, we'll pick up at 9 a.m. tomorrow." And then the next week, my female colleague saying, "Judge, I can't stay late tonight because I'm taking my daughter to a travel lacrosse tournament across state lines," and he berates her for not being available. Just a week later, same judge. And so, and we have to smile, because if we talk back, you can Google this. There was a judge in one of our Northern Virginia counties who incarcerated a female attorney briefly for contempt, because she wouldn't shut up when he told her to shut up, is the short version of it. And so there's a jurisdiction that when I go to litigate in that court, I joke with my husband, I'm going to try to leave out the same door I walked in. And if you get a phone call, you know where I am. And he knows when I say I'm going to that court, he says, "All right, if you're not home by this time, I guess I know to
come bail you out."
Bail me out.
Oh man.
So I think I'm, on the whole, actually, and this is just so reflective of the entire society. Like, on the whole, I think I'm lucky. I don't experience nearly as much of it as what I see certain women in other jurisdictions and in other states experiencing. But that doesn't mean it's not a part of our everyday, or that we're not actively thinking ahead about how to combat it.
Do you feel like, kind of in a similar vein, do you feel like mothers are held to a higher standard than fathers when it comes to like parenting capabilities or violations and things like that, because they're female?
Yes. Also,
Okay.
yeah. I think a great example of this is I had a case last year. My client was the mother, and, just all of the invisible labor, right? That
Right.
goes on behind closed doors. She was the one who remembered what their children's Christmas lists were, that made sure their lists got wrote to Santa, that she bought the presents, that she stored the presents, that she wrapped the presents. That was just one facet of the invisible labor, right? She knew their child's allergies. She knew the last time there had been an allergic reaction. She knew where all the EpiPens were. I had dad on the stand admitting that he hadn't participated at all in responding to any of the emails about the Christmas stuff, right? Like, my client had bought a big gift. It required some extra storage. And she had asked if she could use some space that was like his in the garage based on their, sort of interim separation status. And he just was ignoring her emails, just not responding. So not helpful, not actively inhibiting, but not helpful. He also admitted on the stand to several times that he had given the child food that had induced a allergic reaction. Thankfully, the child is fine. But he was very just laissez-faire about, like, oh, I just hadn't realized that that was on the Costco sample that I fed him, blah, blah, blah. Guy got 50%
Oh my
custody in the
gosh.
summer, right? Like, thankfully, my client still got it during the school year, and that was our huge win. But in giving the ruling, the judge was like, I am really tired of hearing everybody complain about these allergies and this, that, and the other. And it's like, that's
Important.
if a mom had let her child have an anaphylactic episode because she didn't monitor what he was eating, we would malign her. Of course
Yes.
you would. You have to know what your children can eat.
Yeah. That would have been that could have seen that playing out totally different. That's nuts.
Of course. And an example like that is why I empathize tremendously with the cases that are on the margin, right? The ones where there's maybe not what I could legally call domestic violence, but there's neglect maybe, or there's coercion, or there's just like a complete buffoonery, right? Almost of a parent who is just never bothered, but suddenly now that there's a divorce wants 50% custody. And when the other parent reacts so negatively to that, judges go, well, I can't tell if you're being anxious because you think they can't do it, or if you've given them a chance to do it and they've failed. And I can't decide, I can't be speculative. I can't decide this person's incapable of taking care of their child when you haven't given them a chance to do so.
Right. Kind of going back to what I said about you got to wait till something actually happens almost, right?
Versus
And then we can do something.
reactive, not proactive.
Yes. Yeah. Which blew my mind when I came up against that. But it makes, I mean, I guess it does make sense. I mean, we can't predict, we're not fortune tellers, but also we can see patterns here.
And it goes back to, I think, the point we were making earlier about, well, patterns is exactly it. Just because something hasn't happened yet with this person, this child, doesn't mean we can't use the anecdotal data of what has happened in other aspects of the relationship to influence us. I mean, we do it in everyday life. We just haven't figured out how to capture that evidentiarily,
Right.
to say, because this was a pattern here, we now have the data to say that those patterns are going to continue to repeat themselves, no matter how common sense we think it is.
Right.
I still can't get over what you said earlier about the observation, like how we don't really take into consideration the effects that observation of these abuses have on children. Like, that seems like something that should definitely be taken into consideration. And it's heartbreaking that it's not, or hasn't been traditionally, it sounds like, or that there's still studies out there that are not cumulative enough to change it.
And I think, just to close a loop on that, I'm really, when I say that, referring to, we don't have the data for like the long-term psychological, social effects. I will say that if I'm in a situation where I can use evidence of a child has witnessed father doing something to mother, and now whenever father approaches the child is crying, the child is hiding, the child is doing this, and I can also show mom has been trying, Mom has asked dad, go to therapy with the child. Dad is refusing to participate in family therapy. Mom has tried to set up dad for success for a visit, maybe with dad's mother, right? Grandma, let's hang out with grandma and dad. And like, those are the little extra things that aren't required, but I'm trying to encourage my client to do to combat the allegation of alienation or that the domestic violence didn't matter. If those things are all happening, but a judge can anchor some of the child's refusal to go with a parent to what they saw, they will take it into consideration. I'm not trying to say that they don't ever. It's just that I can't, if a child was otherwise willing to go with dad, went with dad for months, then after 6 months stopped going with dad, and mom now wants to say it's because of abuse that the child saw a year ago, I don't have the psychological, social like data to support, oh, well, this could be a latent reaction to that, which would be understandable, but I just don't have that data.
Yeah, no, that makes sense.
Yeah.
That makes sense. Thank you for elaborating on that.
So essentially the studies are very beneficial because then you don't have to, and you alluded to this earlier, you don't have to go through all these meticulous steps to try and prove it when you can and get an expert testimony in here. And then the extra examples you just displayed about, oh, we can connect this event with the child observing this to their current reactions and behavior. Whereas if you had the studies, then you could just cite the studies and that would be taken into consideration instead of all the burden of proof you have to lay out in its stead.
And I will say that to an earlier point I was making also, like where we're talking about triaging efforts, almost every year in Virginia, we have a coalition that tries to establish a code section that says there's going to be a presumption of 50-50 custody between parents in the event of a divorce or separation, and that you have to rebut the presumption of 50-50 custody if you think a parent shouldn't. So far, those laws have not passed in Virginia. But for example, Florida is a state that has a presumption of 50-50 custody. And so not only are we in like our everyday cases trying to think about how to help this one family, we're also keeping in mind that in the background, it might actually end up getting harder. We might not actually be going in the direction that we want to be going because of all of the resources that are being put into trying to create a de facto 50-50 relationship where that may have been far from the norm in the actual intact relationship in terms of the division of labor. So those studies would be helpful, not just to have generally, but to have to rebut the efforts that are being made in certain states for these 50-50 presumptions, because they would provide a reason to say, no, we need to continue to evaluate each case on its individual merit.
This might be a dumb question.
No such
I'm not
thing.
even going to be able to pronounce it correctly. I call it a GAL, but the guardian ad litem, is that what it is?
Guardian ad litem.
Guardian ad litem, yes. I know you said bringing kids to testify is like the nuclear option. Judges do not like that. Is that like a step before that, like getting a GAL?
So in Virginia, there are certain circumstances where a guardian ad litem is actually required to be appointed if somebody asks for it. One of those cases is where there's allegations of abuse or neglect against the child. Not everybody asks for it because for some people or some factual scenarios, it might be a too many cooks in the kitchen situation because they are still an attorney. They are an attorney for the child. And maybe the parents both agree that our own individual lawyers are going to do a good enough job putting forth their version of what is best for the children in court, and we don't need that third person. But there are plenty of circumstances where that person is imperative. While they cannot, and I will say really are not supposed to, but judges are going to do what judges are going to do sometimes. They're not supposed to be able to repeat things that the child said. They're still subject to the same rules of evidence, but they can do an independent investigation. They usually actually have an easier time getting access to schools, to medical professionals, because as the representative of the child, I think the population at large is a little bit more welcoming of them than they are of mom's attorney or dad's attorney.
Sure.
And so they can be a very important tool. They are also human. They are also driven by their own implicit or explicit biases. And we don't get a say in who gets appointed. So I'm always evaluating the kind of risk benefit analysis of, are they going to actually be a value add to the case, or might they, despite their best intentions, create another hurdle for me to overcome when I'm putting on my case. If I have a
Right.
violence victim and the GAL does their investigation and says the children want to have more of a relationship with dad and agree that, they are, that they think that, mom's kind of anxiety is what's in the way. Well, great. Now I have two people that I'm fighting against in court if I'm taking it to court. So it has value. There's always a place for a guardian ad litem in our system. But I do not just go in and ask for it in every case where there's allegations of abuse. I think about whether or not I anticipate it would ultimately be of benefit, or that's not the word that I want to use, but I assess whether it would ultimately be facilitate the perspective of the child. And if I think that the child is comfortable enough, mature enough, otherwise, communicative enough to trust the guardian ad litem and to really impress upon the guardian ad litem what their concerns are, be it safety or otherwise. And do I think that that guardian ad litem is going to represent the interests of their child ward strongly enough?
That was good education. I've never even heard of that before today.
I do have one last question. This has been sprinkled throughout, so so maybe you could just summarize. But how women that find themselves in these situations, how do you think they can best advocate for themselves in the court systems?
Having somebody to advocate on your behalf is always going to be the first step. And again, I'm not just saying that because, I want to stay employed for forever, but having somebody that understands what has worked in front of a particular bench versus what has not worked. I mean, that is just historical data that you as an individual who has never been in court before is never going to have on their own. Having an understanding of the rules of evidence and what can get in versus what can't is really critical, because for women, getting the evidence in is the most important step. But before that, like even before you're in court, before you get the lawyer, you're just in the unfortunate situation that you're in. I would say, sorry, when I'm distilling it down to trying to give moments of advice, I'm reminded of just how overwhelming it must feel to have to make decisions about how to navigate your life every day in a world that feels very stacked against you.
Yeah.
And one of the reasons why I encourage people to come and get a lawyer even before they've actually done the step of separating is because once we have a little bit more data about the dynamics of the specific life, there's a little bit of tailoring of the advice. But generally speaking, and I know that it is so hard, but it's understanding that once you take this decision, take that step to leave, there's going to be discord surrounding custody in particular. If your partner has been one who is controlling, has been physically assaultive, has been emotionally, financially assaultive, they are going to extend that to control of your children. And accepting that that's going to happen, like just as a reality, helps you make decisions within that realization rather than allowing yourself to be surprised that they are exactly who they were to you, to your children. So trying to not engage in it as much as possible. And I know that that's unfair, and I know that that sets a standard. I'm a big advocate of the gray rock method for anybody that has heard of that, in terms of just being as absolutely boring as possible when somebody is trying to be antagonistic to you. Keep records of all of your communications. Even in a good marriage, you're exchanging emails, you're texting, you're G-chatting, you're doing whatever. Don't be deleting those. Don't be clearing them out. Keep your records. Photograph your evidence when it happens. By that, I especially mean of yourself. Be mindful of like the message you're sending to your kids. If you're stripping them down and, taking photos of every inch of their body, that is sending an unfortunate message. Concurrent documentation. If something has happened to your child, you take them to the pediatrician, answer the questions, but don't narrate, right? You think your child has been abused by somebody, whether it's your spouse or otherwise, remove yourself from the reporting as much as possible. And that's just because anything that you say, however well-intentioned, if it finds its way into a medical record, it finds its way into an affidavit, it finds its way into a police report, those are the words that are going to get used against you by your spouse's attorney in the future. And so if it's somebody else's words, there's a layer of insulation that's provided because somebody else made a decision, much like the judge making the decision about family abuse in a protective order situation, right? Having somebody else that has said, I'm concerned about this, is validating just for your own mental health as well. When you're in the separation phase, as much as you think you're being helpful, when you're going to your son or daughter's teacher and saying they're going through a bad divorce, their dad is left, they've done this, that, and the other, he was this, same thing. If I issue a subpoena to those schools, I get those emails. I'm using that to say you were trying to poison the teacher against dad, or they're going to say you were trying to, right? It's our job. So I'm kind of just trying to show you how to get around that. Which isn't to say don't share your concerns, but just be mindful about your framing. Lean on friends as much as possible. Lean on your family. I know isolation is a huge part of the world of domestic violence. And you might not have somebody. See who in your neighborhood or in your community has a women's center. We have in Northern Virginia the Women's Center, and it's a confidential resource for women to get therapeutic services, shelter services, therapist recommendations for their kids. There's always a starting point to that next phase of your life, and trying to find that will help remind you that you're not alone, and will also help give you the advice that, some version of what I'm giving, although not, legal advice. I kind of just call it person advice, to try to protect yourself and strengthen yourself for what is going to be probably the most emotionally arduous journey you've been on. I feel like that is a very incomplete answer because it's so hard to answer. It's so individualistic to try to help each person get out of the situation that they're in.
You probably have your own mental health that you have to protect. I can't imagine all the stories and all of the cases and just having to go through that. I mean, I'm in the medical field and I know how hard that is, just being in the medical field, but then to actually have to go to bat for somebody. And then, that's what you do is amazing. So I just appreciate you very much being here and talking to us about all the things. That was so informative. I learned a lot of stuff. And I think that it's going to be very validating, messages after messages of women that have just experienced everything that you're talking about.
Yeah.
And so hopefully they feel heard and seen through this. And I just appreciate so much of your time. I know we went over a little bit, so I just appreciate it though so much. And thanks for being brave and coming to do it. I know you said you were nervous, but you did awesome. You did so good. So thank you so much.
Yeah. So informative, so practical.
Katie and Jay, thank you so much for the opportunity. I hope that it provides a little bit of hope also. I know it's a dark topic. I know that it can leave women in particular feeling hopeless. But my goal is that in educating, it's allowing for tools to show that there might still be a path to the conclusion that they're looking for. It just maybe is a slightly different path than the one that they thought would be the most direct.
It kind of reminds me of getting Al Capone on taxes, honestly. You can't prove necessarily one thing to really seal the deal, but you can prove something else, which obviously, his criminal industry and taxes are very different, whereas coercion and domestic violence are not necessarily that different, but that's what it reminds me of.
Yeah, right.
No, I think
get them somewhere.
It is adapting to the system in which we're in. And if the rules of evidence change, then our, strategies are going to change. If new studies come out, our strategies are going to change, but we are not the makers of the system. We are just operators in it. And even the judges are just symptoms of a larger kind of condition, right? People want to say, oh, that judge this and that judge didn't understand that. And that's valid to a point. It's one of the reasons why we're so excited when we see more women on the bench, right? Because they do bring a little bit of that understanding about the mental load, the invisible labor, and all of that. And so their experiences are also prevalent in their, back of their mind. But at the end of the day, they're bound by the legislature, and they're bound by the code that was written and the factors that the legislature told them that they had to apply, and the burdens of proof that the legislature or that higher courts have said you have to find to be able to make these decisions. So, at the end of the day, I could really just blame patriarchy. But
we do that a lot here.
Well, and it is, because we are all but symptoms of the cause of patriarchy. And so as we start to dismantle that in other places, representation, women on the bench, women in law, we're slowly trying to change the conversation, but it is very slow, and we are limited by the tools that we are given.
I hope for those of you listening, something was intriguing or sparked a curiosity, or you felt affirmed or challenged. Stay educated. Take the pink pill. If you enjoyed this podcast, please give us a follow and maybe a nice review.